Let me first of all tell you a little bit about the history of the Heller case. As most of you probably know, this is a Second Amendment challenge to the District of Columbia's handgun ban, as well as a challenge on certain other restrictions in D.C. law on rifles and shotguns. It was brought originally back in 2003. It was always intended to be a test case with the intent to establish a broad new legal precedent guaranteeing an individual right to own guns. Interestingly, it is not a case that was brought by the National Rifle Association. Actually, the mastermind and sponsor of the case is a man by the name of Robert Levy, who is associated with the Cato Institute here in Washington. It's a libertarian think tank. He went about constructing a very appealing test case for the courts. He and his colleagues carefully recruited the plaintiffs who would be asserting these claims. He recruited law-abiding citizens. These are not criminal defendants who are seeking to escape prosecution for violating a gun law. And he brought the case in the District of Columbia, knowing that the U.S. Court of Appeals here in the district had become, in recent years, quite conservative. So it was a well-planned, well-thought-out case. And sure enough, last year, our fears about this case were realized to some extent, because last March, in a 2-to-1 vote, a 3-judge panel of the District of Columbia Circuit Court of Appeals did in fact strike down the laws being challenged. And this was the first federal appeals court decision in history to strike down any gun law of any kind on Second Amendment grounds. Let me say a brief word about the state of Second Amendment law before this case was brought. 9 other federal circuit courts had held that the right of the people to keep and bear arms in the Second Amendment relates exclusively to participation in an organized state militia. And in fact, those courts held that the Second Amendment really has nothing whatsoever to do with the use of guns for personal purposes like self-defense or hunting. Well, why was there such a strong consensus among the courts about the meaning of the Second Amendment and about the fact that the Second Amendment relates to the militia? Well, my best answer to that is because that's what the Second Amendment says. Let's review the words briefly. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And in the only extensive holding by the Supreme Court about the Second Amendment, a case called United States versus Miller, brought back in the Depression era, the Supreme Court in fact held that the obvious purpose of the guarantee of the right in the Second Amendment was to ensure the viability of state militias, and it even said the right must be, quote, interpreted and applied with that end in view. Pretty clear instruction from the Supreme Court back in 1939. Well, the result of this judicial consensus was, for all these years since Miller, gun laws have been routinely upheld by the courts because they don't interfere with the arming of a militia.